Working? And I never know. One of these days I'll have this technology all the way down. Let's check the phone. I think we are, though. I think we're good to go. Yeah, we're good to go. Test. Love it. How we doing? How we doing? As always, this is not legal advice. We do not offer legal advice. If you need legal advice, reach out to an attorney. This is for informational, educational, and entertainment purposes only. Getting started today, talking more about the trustee. I might be redoing part 3 over. The other day when I did part 3, I was feeling a little bit, I don't want to say ill, but I felt a little ill, I guess, which is weird because I never really get that sick, but I was just feeling a little off, so I might end up redoing part 3, because again, this is about not only just solidifying this for myself, I have this pretty down pat, but also making sure, again, like, I put my best foot forward for you all and create content that is going to make this so easy that a caveman can come out of the Caucasus Mountains, literally stroll right out, watch this video, and start to make his own trust and operate as a trustee. I hope that helps. I hope that makes sense. If you have any questions, please feel free to reach out anytime. Love to help you out if we possibly can. We don't give advice. We don't give recommendations. We just listen to people, if that makes sense. So with that being said, let's see what we talked a little bit about there. It was pretty straightforward, but there were some things that I wanted to go more in depth about in terms of the trustee's powers and duties last time. So again, I'm thinking about it. I might redo that part 3 again, but today we're going to get into it. It's about 3:04 Eastern Standard Time, 12:04 Pacific Standard Time, daylights, whatever, it doesn't matter. The clock says what the clock says. So it'll probably go to the 50th minute or so, give or take. No longer than that. So with that being said, let's go ahead and get started. So we're talking about today privileges and liabilities of the trustee. So let's go ahead and get into it. I'll make sure that I take this very slow again. If for some reason if you think I didn't explain something very well, or you think I'm wrong, please attribute it to me, no problem at all, instead of the express trust, because there is so much power. Again, I'll say it every single time. When you decide to operate as a trustee through a private express trust as compared to through your persona in commerce. So let's get started. In addition to powers and duties, there are certain privileges. Let's look at that word privileges. Let's just start it off. You know what? Let's just look at it, because like every word, you gotta, a lot of getting into this is really about reconditioning your mind and your understanding of the etymology of words, because we've been told to believe things and understand things which aren't actually what they appear to be. I went in depth, like part 1 is very, very good, in my opinion, to understand our society, if that makes sense, through personas, persons, that's what that word is derived from. Why is this taking so long? They don't want us to be great today. Privilege? Oh, come on. Privilege. Oh, it would probably help if I spelled the word right, huh? Yeah. It's either with an I in there or an E. Apologies, guys. I'm not sure why it's taking so long. I think it's an E. I should know this. No, it's an I. Okay. Privilege. Oh, man. Come on, give me the... Give me the definition, just for the word privilege. I don't know why my Wi-Fi is acting all funny today, of course. Never have problems with Wi-Fi. Privilege and immunities, the right of... of course. Let me see if it just gives the word privilege. Oh, yes. Particular and peculiar benefit or advantage enjoyed by a, what? Person, company, or class beyond the common advantages of other citizens. An exceptional or extraordinary power or exemption. A right, power, franchise, or immunity held by a person or class against or beyond the course of the law. Privilege is an exemption from some burden or attendance with which certain persons are indulged from a supposition of law, that the stations they fill or the offices that they are engaged with are such as require all their time and care, and that, therefore, without this indulgence, it would be impractical to execute such offices to that advantage which the public good requires. A right which the nature of debt gives to a creditor, etc., etc. In maritime law, an allowance to the master of a ship of the same general nature with primage. It's like, this is deep. I'm going to boil it down to you. Here's a good one. The right of a particular question, motion, or statement to take precedence over all other business. Everything's business-based. Oh, here we go at the bottom. Let me start. The matter may be one of personal privilege, where it concerns one member of the House in his capacity as legislator, or the privilege of the House where it concerns the rights, immunities, or dignity of the entire body, or of constitutional privilege where it relates to some action being taken or some order of proceeding expressly joined by the Constitution. So this is where we are right now. This is the constitutional privilege that we are talking about right now. But when we talk about privileges and benefits of the 14th Amendment citizen, we are not talking about good privileges there. They may appear good on their face. They may appear to be rights, but they are not. The privileges of the trustee, the private express trustee, are greater in length, breadth, and depth as compared to the 14th Amendment citizen, because that is of the common law, whereas the the 14th Amendment citizen is of the statutory law. We remember when we talk about public versus private being Constitution, public being the statutory. Remember, the reason why they made it public is so they can have an interest, or aka a right, in the affairs to meddle in tax, to fine, which is a tax, if that makes sense. But I just wanted to break that down. That word is very important. Rights and liabilities of the trustee. These are all those which are enumerated in the trust instrument and naturally extended to the trustee of an express trust. As was noted earlier, certain restrictions placed upon trustees of ordinary trust do not apply to trustee of an express trust, pursuant to the doctrine of greater latitude. These, aside from those allowed by the trust instrument, include but are not limited to, and before we get into that, I'm going to go down to footnote 76 here. It talks about greater latitude. Ashworth versus Higgins. So understand this. The reason why, I just explained it, the reason why the trustee of an express trust has greater privileges and all that compared to a trustee of a ordinary trust or a statutory trust is because the benefits of the common law far I combined two words there, but they far surpass the benefits and restrictions, I guess you could say, of the statutory law, if that makes sense. So let's continue. What are these privileges? The inherent, unquestionable right to full compensation, including reimbursement of all out-of-pocket expense and other expenses incurred in the discharge of duties. This is why it's important, like I was talking about last time, to keep good records, minutes, etc. And unduly withheld and reimbursement results in a lien on the trust for the amount plus interest. So basically what that's saying is, let's say you're a trustee of a private express trust and you incur some expenses and they are not the trust or the other, let's say you have to go to the board of trustees to, or the other co-trustees, which is the board of trustees that you're part of, to get a reimbursement of those funds, and they're not willing to do so, well, then you can go place a lien on the trust, if that makes sense, because you're using your quote-unquote personal funds to carry out trust business. Let's continue. The privilege of residing within the trust estate and allowance of rates and taxes, although the trustee, has the benefit of residing in the house. This is a big one, because everyone's like, oh, well, what am I going to do once I sell my property into trust? I can't use it. I don't own it. You don't want to own it. You don't want to own it. The name of the game is own nothing, control everything. You don't want to own it. You don't want to own anything. Nothing is in your personal name. Let's look at these footnotes here. Let's talk about the last one about compensation. James Hill Super Act, Part 4, Division through 2, Chapter 4. Such is the rule of courts of equity, and such also is the rule at common law. So there you go. That's the rule of equity and common law. So like that's not made up. That is signed, sealed, delivered. 78, talking about must pay him himself and will not be allowed his wages out of the estate. So basically, like as a trustee, if I'm trying to delegate some duty of the trust estate, I want to go hire a manager for a particular purpose in regards to the trust estate. I can do that, but I have to pay it out of my own pocket because now I'm being lazy, essentially. Let's keep going. And so a trustee with the most ample powers of management cannot, of his own authority, keep up a mere pleasurable establishment such as gamekeepers, etc. I'm not sure why that footnote is exactly there, but I did want to point out that part of him being the trustee being lazy in that regard. Again, like I talked about last time, if you're willing to be a trustee, if you're wanting to be a trustee, it's more than just tax avoidance, which is 100% legal. We don't practice or preach or talk about tax evasion. Anyone that's telling you to do that, run away. Run away. Run away. Literally, do not listen to them. We don't evade taxes. That is wrong. That's going to get you in trouble. We don't do that. This is not legal advice. This is not financial advice. This is purely entertainment and educational purposes only. But other than tax avoidance and asset protection, it's just called being in control, having your crap together. Not letting the government tell you how to do things and what to do and them dictating you on anything. You're in control. Let's continue. The right to employ a solicitor for assistance and guidance in the administration of the trust, and, in the case of any doubt or difficulty, to seek the opinion of competent counsel, and, in the case where the trust accounts are intricate and complicated, to seek the assistance of an accountant to the charge of the trust. So, when we talk about this privilege right here, we talk about a solicitor. Let's look at the footnote before I start talking. This is defined as a person who conducts matters on another's behalf, an agent or representative. So this does not have to be an attorney. This is not legal advice. Just telling you, it does not have to be an attorney. As a matter of fact, I would advise against that. I would just advise against that. This isn't legal advice, but I would be very cautious. Let's just say that. The reason why is because, again, attorneys are public. We're trying to operate in the private. We don't want to grant any public interest to this. Not even public interest, because we might decide with our trust, we might want to engage in public commerce. But at the same time, we don't want to give a public official hands or any insight to our trust dealings. That's why, again, being a competent trustee and doing your own research is big. Now, you can find people who are well-versed in this matter and give them a gift or a donation to help you with your trust affairs. That's something you can do. You can seek help of an accountant, et cetera, but just make sure when you do these things, again, it goes back just like the trust is a contract. You draw up a contract to that. No, nothing implied. Don't leave it up for interpretation or anything. You strictly state the terms of the arrangement. You have them sign it. And you make sure you get the board of trustees, if there's a board. If you're a sole trustee, you're a sole trustee. You make sure that it's well approved and well written. Continuing, because accounting is hard. Accounting is hard. It can be hard, especially if you're deciding to play the commercial game where you are going to incur a tax liability. You don't want to hem yourself up, if that makes sense. The right, because remember, like income is dependent on the source. Just because you have a common law trust does not mean you're automatically going to avoid taxes. That's dumb. Sorry. It depends on where it's coming from and how it's coming in, or if it's even income to begin with. Is it a gift? Is it a donation? Or is it real income? If it's real income coming from a United States Inc. source, then you're going to have to pay taxes on it. But the thing about a trust is you have expenses that can help you mitigate some of that tax liability legally. Let's continue. The right to apply to a court of equity for directions in the execution of the trust, or to obtain a declaratory judgment in order to establish the meaning and intent of the trust instrument. That can't be horrible. This is a good one. Especially if you, say you're a successor trustee, and you just came into trustee's shoes. Okay, there you go, But again, I wouldn't advise anything. I never advise anything. Me personally, I would do my research first. Continuing. The right to carry on in separate business for the benefit of the trust, given certain conditions, to be compelled by subpoena or review to produce and show records or books to outside parties. See Boyd versus U.S. I kind of want to look this up. What time we got right now? We got 30 minutes. I don't know. Later. We'll do it later. Another time. Next one. The right to further limit his liability in particular contracts, even beyond the limitation made in the trust instrument. That's a really good one too. We'll talk about that later. I'm not going to talk about that right now because it covers it later. The right to relocate, move trust property, or change the trust domicile. See 82. This is a good one, I think. The court said, we have repeatedly held that representatives may stand upon their own citizenship in the federal courts irrespective of the citizenship of the persons whom they represent as executors, administrators, guardians, trustees, receivers, etc. This is the one we want. We're not, I mean, there's a time and a place. This is what you got to get through your mind. You are not a person. Corporate things are persons. Please remember that. Go watch part 1 because we covered that in depth if you have not. And the inalienable right to disclaim the office at the execution or resign at a later date. Pretty straightforward so far. I think I've covered things in depth. With regard to the personal liabilities of a trustee, basically, the inherent liabilities and non-liabilities are all those incident to ownership at law. What did I just say? What do we want to talk about? Own nothing, control everything. But let's continue. I want to go on my high horse right now. And imposed or exempted under contract law. For it is a maxim of law, they contract fight la loi. I think I said that right. I was trying to be fancy there. The contract makes the law, is what that means. The basic principle is that all man's law is contractual in nature, regardless of the particular classification of the law, meaning admiralty, maritime, equity, civil, whatever you want to call it, common law. The contract can acquire force only by consent. Consensus facile again. So, understand that. If you start to understand contract law and you start to understand trust law, you can do some really good things in this world, in this life. Truly. Again, let's look at the very first contract that was made between our Creator and the first man, Adam, either way, right? So understand this, it was a trust that was created. Our Creator trusted Adam as a trustee to take care of the earth for the kingdom of heaven, which is the beneficiaries. I said this in the first part. If you didn't watch it, go and watch it. Does that make sense? When Adam stepped into that role and he disobeyed because of Eve, then he was kicked out from the Garden of Eden and onto the lesser plane, if you will, if that makes sense. Let's keep going. Therefore, a trustee's liability is largely determined according to the particular circumstances of the situation, especially contracts wherein the trustee has properly limited his liability via qualified signature. Discuss the principles of and procedure for properly qualifying one's signature in a later section. No, we're not. We're going to do that right now. For now, we will entertain the general liabilities. Basically, when you go and sign your name, there's a couple of ways. You can sign your name uppercase, lowercase. You can do the Christian appellation, which is first name, dash, middle name, colon, last. You can just do it normal. But after you put a comma and you say TTEE. And above it or below it, you write all rights reserved without prejudice. There you have it. You just limited your liability just like that. Very easy. And everything is a contract. If you're signing something, you need to assume that it's a contract. Just make that assumption. Make it. If you're signing your name on it, it's a contract. If you're signing something and has a social on it, which we want to get away from that eventually, you definitely want to make sure that you sign that way, because you are not that social. Matter of fact, the social doesn't even belong to you. It doesn't matter if you apply for it or not. It's not yours. It is United States property. Go check the, I want to say it's the Privacy Act, but I want to say it's another place as well. I can't remember where it says it. It's not, it's federal property. It's federal property. So that's how you basically limit your liability through qualified signature. That's extremely important. Because it's contract. You're signing as a trustee, essentially. Which, as a 14th Amendment citizen, you're the beneficiary when it is fitting for them to place you underneath their jurisdiction. But when you're brought into court, then they make you assume they essentially make you walk into the chair of trusteeship, because the trustees have all the liability, like we are reading right here. So you go from beneficiary to trustee without even realizing it. This is why you get charges. You're essentially volunteering. A lot of people don't know this. Let me stop. Let's keep going, because we can go deep on this if we really want to. But let's look at the liabilities. General liabilities. Liability on all contracts made, whether signing as a trustee or signing individually. 85. Simply using the title trustee will not sufficiently limit the liability in certain contracts, such as debt instruments and agreements which fail to specify the non-personal capacity of the trustee. That without some express stipulation he is personally bound is well settled law. This is why I said all rights reserved as well. If you're doing trust business for a contract and you put TTEE, I'm gonna hold off on that. Me personally, I think that would be sufficient, but I can understand why it would not be as well. Because you are contracting on behalf of the trust. However, they're looking to attach. They know that the trust is the one truly incurring the debt, but they're going to try to attach that to a so-called person, another person, if they will, if that makes sense. Let's continue. Liability of removal for breach of trust, waste management, or good cause shown in an action for removal in a court of equity or according to trust instrument. Again, this is the fiduciary duty we talked about last time. It is your duty to increase and enhance the property, the res, and the investments, whatever is in the trust, to take care of that. If you don't, you're going to get booted. Now, if it's through a mistake, that's one thing, but if it's through just being lazy, it's the same exact thing, or through disobedience. Just like Adam, You get booted. You removed. Sorry. Let's keep going. This is why, for those who read the Apocrypha really quickly, this is why Enoch was the first person taken into heaven. Because Enoch was a good trustee on the earth. He despised the ways of men, and then he was brought into heaven and then conducted in the Garden of Eden. Go read Jubilees chapter 4. It all ties back to trust. This natural law, spiritual law stuff, it all connects. You just have to see the connections. And it's going to make it clearer and clearer for you. But when you don't, when you do what you're supposed to do according to the trust documents and according to common law, spiritual law, law of equity, etc., you're good. So don't let this liability part scare you is what I'm saying. That makes sense? Let's continue. Liability for losses sustained by the trust as a result of negligence. Let's look up well, I don't even need to look up negligence. But in order for there to be negligence, you obviously have a duty of care, which is if you sign up for a trustee, you have to, you're basically agreeing to care for the trust property. And now I'm losing my train of thought because, it's duty of care, proximate cause, I'm not going in order here, and obviously damages as well. Let's just look. Because I know I'm paraphrasing that, and I don't want to paraphrase anything. I want to make sure we get this all the way right. Talk about negligence. You cause damage. Let me just look. Let's just type this one. Why not? Or click this one. So, negligent lawsuit is a civil lawsuit that is filed against a person or legal party that failed to use reasonable caution and cause damage. This is a part of the duty of care. While providing care or services, negligence cases are usually brought against certain category of professionals, medical, etc., proven as negligence. 4 main elements. So any lawsuit has what's called essential elements. Understand this, because if you don't prove your essential elements, because a negligence is a cause of action. That every lawsuit has to have a cause of action, otherwise you file a 12B motion to dismiss, if that makes sense. You have 4 main elements for negligence. It's duty, breach of duty, proximate cause, causation, and damage. So I was right. I was just paraphrasing it. But understand this. For every cause of action, there is an affirmative defense as well. Each one, when I say material, we're talking about facts that are directly related to the outcome of the case of the matter, if that makes sense, and prove them. Allege, move, prove when you're in a lawsuit. Just breaking down some bars. I know that's a little tangent, but I want to make sure that you guys understood that. What are we looking at on time? We still got 20 minutes, so we're good to go. All right, let's go. Liability for losses by the trust as a result of negligence. So basically, don't be a dummy. Do your due diligence. Liability for torts and common law criminal wrongs, criminal and civil wrongs or acts of bad faith. Acts of bad faith. One, you cannot walk into equity with what? Anyone know this? I don't know if anyone knows this one. You cannot walk into equity with unclean hands. Let's see, the footnote there is 88. Bad faith. However, in torts and civil wrongs, limitation of liability is amply available as per fisheries, supra. Common law crimes are strictly of an in personam nature, going against the officer personally. But you can't walk into equity with unclean hands. Bad faith, unclean hands. Let's just look it up. Unclean hands doctrine really quick, because we got time today. Not feeling a little under the weather anymore. So let's look at it. That's it. The doctrine that a decision should not favor the plaintiff who has acted accordingly, and honestly, let's just type in clean hands doctrine. It'll probably give us clean hands doctrine somewhere around here. Again, if you don't use this website, this is really good. You want to get Black's Law. Here we are. You want to get Black's Law 4th edition, because the later editions take out some key pertinent information, and the earlier editions are not as up to date. But 4th is pretty good. Legal principle states that the party requesting equity in judicial action must not be involved in any inequitable or fraudulent dealings. For example, a thief cannot get the court's help in the recovery of stolen property that he himself stole. And then right below it has another definition as well. If it loads fast enough, I'll read it, and then we can move on. Hope we're all doing well. Hope we're retaining some good information here. It is a rule of equity that a plaintiff must come with clean hands. He must be free from reproach in his conduct. Man, let's pull this one up, because this is good stuff. But there is a limitation to the rule, that his conduct can only be accepted in respect to the subject matter of his claim. So I can't claim unclean hands against someone for a case talking about trust document or trust mismanagement or whatnot. If the reason why I'm claiming unclean hands is because somebody posterized and dunked on a kid on a pickup basketball game and pushed him down afterwards. It's not related to the subject matter. The basketball game has nothing to do with the trust affairs. So that, just to clear that up for you guys. I love this legal stuff, man, and the definitions that come with it. I don't offer legal advice. This is not legal advice. If you are seeking legal advice, please go reach out to a registered attorney. This is for educational and entertainment purposes only. But this is a big one because, like, a lot of people think, well, oh, I'm a trustee. No, you have to act in you're still underneath the common law jurisdiction, so don't do anything dumb. Liability in cases of commingling of trust funds, 89. I want to read this one because this is good. Generally, in cases of this is bad, so pay attention. In cases of commingling of the trustee's personal funds with trust funds, courts will follow the trust property unless commingled beyond separation. In which case the courts will treat the trust as the alter ego of the individual acting under the assumed alias of trustee and will ignore the trust arrangement completely. Mixing trust property with personal property is commingling. In man cases, however, it should be noted that, commingling or not, I'm starting over because you please pay attention on this. This is huge. This one is huge. Please pay attention. Generally, in cases of commingling, meaning the mixing of the trustee's personal funds with trust funds, courts will follow the trust property unless commingled beyond separation. In which case the courts will treat the trust as the alter ego of the individual acting under the assumed alias of trustee and will ignore the trust arrangement completely. It's like an LLC. Like literally, it's like an LLC. You got an S corp. You got an S corp or whatever now, and they're gonna tax you because of it, if that makes sense. Unless you never gave your social or whatnot and all that stuff. Which you shouldn't, or you don't get, like, let me continue because it talks about this. See Gregory versus Helvering. Mixing trust property with personal property is commingling. See Perry on Trust, Volume 1. In man cases, however, I'm going to read this slow. It should be noted that, commingling or not, in rem jurisdiction meaning jurisdiction over things, personal jurisdiction over persons, not over trustees who are, if you're a trustee of a private express common law trust, you're not a person, you are a person in the sense of the common law, not in the sense of in rem jurisdiction of Admiralty Maritime. In rem jurisdiction is waived by the defendants, giving way to these at-law actions. Ignorance of procedural defects relating to in rem jurisdiction is the real cause. Like, come on. Amazing. You gotta understand this. Basically, what this is saying is, I don't advise anything. This is not legal advice. This is entertainment and educational purposes only. But if you are going to commingle, I would never commingle. Me personally. Emergency may happen, you might have to do it once or twice, put it back. That being said, if you commingle, for some reason if you get caught commingling, they should never be able to drag you into court. If you do, you don't understand how to operate as a trustee. And the reason that is because there are no more common law courts. There are no more. You're a common law, bro, understand this. We're going to talk about this later. It's down here talking about jurisdiction. It's all the way down here. They should, it's way down here. Come on. Yeah, here we go. Jurisdiction. The way they obtain personal jurisdiction, they should never be able to obtain personal jurisdiction over a living flesh and blood trustee. Does that make sense? Let me go back to it because I want to read over. Get this fundamental understanding down, everything opens up. A lot of people, it depends. Some people find this because their friend gave it to them. Some people find this because they believe in alternative theories. Some people find this because they were desperate, fighting for their lives, fighting for their families' lives, fighting for their kids' lives. What? Is that what I clicked? In personam in rem. Oh, no, they did not. Bro, you guys see what I'm seeing, right? It literally is changing the definition. I don't like that. In the Roman law from which they are taken, in rem and in personam are always opposed to one another, and act of proceeding in personam one wave. I want to go through this because this is big. Wave it. I want to read this so bad. They're probably not gonna have anything for me. So basically, I'll go through it in my own words because I know I'm right on this. This is one thing I know I'm right. I've researched this extensively. So there's plenty of case law on this. If someone files a suit against you, whether it be civilly or admiralty, it's really civilly, because all the courts or the cases technically are civil. They have to serve you through certified mail. Most cases. Some states have different rules or whatnot. You should do in any case against you, no matter if they have it or if they don't. They're right or they're wrong. You're in, you're out. You challenge jurisdiction. Very first thing. Always, 100%, without a doubt. Do not do anything else. Don't pass go. Do not collect $200. Do not do anything other than challenge jurisdiction. Because they have to prove it on the record. If they cannot prove it on the record, they have to dismiss the case. Because jurisdiction is the basis of which everything operates. Subject matter jurisdiction, which can never be waived, but personal jurisdiction can be waived, as we see right here. Always challenge it and make them prove it. Don't let them go forward, because there is well-standing case law from the Supreme Court, which again, we talked about this, is mandatory authority. Mandatory authority, meaning they have to follow it. So for whatever reason, if they violate you and you go to the Court of Appeals, they're going to overturn it, because they are bound by that ruling. These lower courts, these county courts, these municipal courts, they're bound by it, but not necessarily because they're operating in the admiralty jurisdiction, if that makes sense. This is not legal advice. This is informational and entertainment and educational purposes only. So always challenge jurisdiction, no matter what. Always challenge it from the writ, the very first thing. And don't put any other pleading in the case other than that. Let's continue. I could go on and on about that one, because I had to get it out the mud. I'm actually getting it out the mud. Let's keep going. Liability for all mischief of his agents contracted to exercise discretionary power. So basically, you didn't want to do something, or you didn't have the ability to do something, so you contracted someone, and that agent did something bad. Okay. But the trustee is not at all liable for any losses sustained in the proper discharge of duties, and in the case of other losses due to negligence or tort, the trustee may be able to be bonded in the manner ordinarily, by executors and administrators. They are generally not liable for contracts in which liability was properly limited using the methods to be shown later, and I explain. Such contracts may also encompass the codes and statutes of various jurisdictions, given that all man-made law is by its nature fundamentally contractual. Now that's important because that is what, again, like I said, that's what the UCC was made for, the uniform making all, let's look it up. I'm gonna show you. We're gonna look it up now. We're gonna get this working. I can't even spell Google right. I'm typing with one hand, so please forgive me. What I want to look up. UCC 1-103. This is a gem. They're all gems, but this one especially. Construction of Uniform Commercial Code to promote its purposes and policies. Applicability of supplemental principles of law. The Uniform Commercial Code, also known as the UCC, must be liberally construed and applied to promote its underlying purposes and policies, which are 1. To simplify, clarify, and modernize the law governing commercial transactions. 2. To permit the continued expansion of commercial practices through custom usage and agreement of the parties. And 3. To what? To make uniform the law amongst various jurisdictions. And this is the gem right here. Unless displaced by the particular provisions of the UCC, the principles of law and equity. Law. We're talking about law, not code. Law. Meaning the Constitution, case law, common law, and equity. Unless displaced by particular provisions, including the law merchant and the law relative to the capacity to contract, which is private, principal and agent in the Constitution, estoppel in the Constitution, fraud in the Constitution, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating causes supplement its provisions. Long story short, it is supplementing the common law, not getting rid of it like people try to say that it is. Go read it for yourself. Let's continue. The debts of the trust incurred requiring the creditor to look solely to the trust for payment. That is, if you decide to contract your trust. Here's the thing. Word of practicality, because I don't offer advice. If you're going to contract with a trust, with someone in the public, a creditor in the public, or anyone in the public, in any venture that is even a shred of a risk, because there's always a little bit of risk with contract, right? Use another trust to do it. Diversify your assets. This is why you don't just put $100 million of your money in the banks, because they're only required to hold 10% anyways. So then you go to withdraw, you only got 10 million in there, and you got 0.0037 interest on it. You diversify your assets. You put it in whole life insurance policies. This is not financial or legal advice. You put it into gold and silver. You put it into crypto. I know. Shoot me. You you put it into private commercial market. You put it in whatever you want to put it in, stocks, whatever. Your call. The same thing with your trust. You put your assets in one trust. You put this asset in another trust. You put this asset in the family trust. You put this in the 508 trust. You put this in that trust, etc., etc. That way, if something does go down, you are limiting liability. Let's continue. Conversely, the trust is not liable for the personal debts of the trustee either, except to the extent of the attachability of the trustee's interest in the trust. 93, 94. Nothing there. I was going in today. 3 minutes. How long is authorized representatives? We're going to go through authorized representatives, and then we'll shut it down. Let me finish this part, though. Woo! The independent, non-preventable acts of co-trustees of which he had no prior knowledge. So basically, like, if a co-trustee decides to go rogue and do something against the trust, you're not liable for it, except if the acts were indeed preventable and he had prior knowledge, and the trustee is co-liable and accountable for the loss. The acts of his agents when properly contracted, taxes on the income of the trust. Again, the trustee must be indemnified by the trust instrument from taxation for trust gains. If the trustee holds interest in the trust, He is taxable only at the realization of an actual gain, not at the point of investment. Point of actual gain depends on what asset you're investing in, or you're purchasing or buying, whether it be stocks, which could be when you finally decide to sell the stock, or it could be real estate when just the point of sale, etc. Or it could be something, it might be a business, it just depends, it varies. And lawsuits against the trust. So, you are not liable for those things. Finishing up here, authorized representative. As shown above, it is well within the power, discretion, and oftentimes duty to contract an authorized representative, managing agent, or attorney in fact. Let's look up attorney in fact. Hang with me, we're almost there, we're almost done. I always want to try to keep these to 45 minutes because I know what that attention span be like sometimes nowadays. Attorney in fact, this is good. A private attorney authorized by another to act in his place. A what attorney? A private. We're not talking about a bar attorney here. This is not legal advice. Either for some particular purpose as to do a particular act or for the transaction of business in general, not of a legal character. Again, legal versus lawful. Legal is public. Lawful is private. This authority is conferred by an instrument in writing called a letter of attorney, or more commonly, a power of attorney. Here's a case law that supports that. And the basic rule which courts of equity have laid down is that a trustee may contract such agents to handle all affairs which require no discretion, be they ministerial or not, and he may not delegate the essential part of the power unless, of course, he's permitted to do so by the trust interest. So basically, you can delegate your authority until it is an essential part of your office as a trustee, your duties as a trustee, unless the trust instrument says that you can do that. Continuing. In clarifying the discretionary power rule, it must be noted that there is no law against delegating discretionary powers to agents. The rule is simply that a trustee who does so at his own peril, buyer beware, essentially. For he is liable for all losses generated by the agent, if any. Let's keep going because it's going to expound upon that. To clarify what constitutes the essential and unessential parts of the power, the essential part is defined as the exercise of discretion, the determining of needs of the trust, or the appropriateness of an action. The unessential part is the not requiring the exercise of discretion, etc., etc. However, there is a simple solution, allowing for greater flexibility in this rule. The solution is to authorize the agent to contract on behalf of the trust, subject to the assent of the trustee. And as noted in the previous section, if the trust instrument makes provisions for the contracting of an authorized representative, then the trustee cannot be liable for his acts. Lovely. It should be noted here that in the previous section, it was shown to be a general duty of the trustee to minimize any potential risk, not only to the trust, but also to himself when contracting agents. In cases of uncertainty, the trustee may require that the agent be bonded for a certain amount which would satisfy any potential general or specific loss, assuring the trustee the trust of the good faith performance of the agent. So basically, like, you can get the authorized agent to contract on behalf of the trust instead of on your behalf, if that makes sense. Basically, you're limiting your liability. Where have we heard that before? Oh, is that LLC, limited liability? Let's keep going. Now, the method for contracting such agents may be either by formal appointment if mandated by the trust instrument, or by execution of a limited power of attorney, letter of authorization like we just read, all that, or even certificate of verbal authorization documented by minutes of meeting. I would always do it written, though. The most effective, secure method of contracting such an agent will obviously be an actual appointment with a written contract, as it says, setting forth the specifics of the position. But a letter of introduction is, for most purposes, sufficient, as is a simple power of attorney when the agent is acting specifically under the title of attorney in fact. I have supplied the reader with a sample multi-purpose letter of instructions for opening a bank account in the sample forms of this section. All the reader needs to do is modify the letter to encompass the particular purposes, etc., etc. I'm not going to read all that. Sample authorized representative form contract as well. So basically, depending on this next part's going to be really good, but depending on how serious the affairs are and how you're contracting these powers out, me personally, I'm always going to write it out. That's just how I am. I want to be thorough, make sure I'm covering my tail, crossing my T's, dotting my I's, all that fun stuff. But yeah, that's pretty much it. I don't think we have anything else we need to cover. I think today's was really, really good.
Amazing!
So, with that being said, if you got any messages, make sure you do us a favor. Go and follow us on Twitter, on Instagram. Govern yourself accordingly. Govern.yourself.accordingly. Give us a shout out. Give us a like and subscribe on here. Trying to build our following solely for the purpose of giving people the information that they need in order to operate in the proper status and the appropriate way that this world is going. Because whether you like it or not, things are changing. And being able to operate in a particular way is going to set yourself up for success. Albeit more work, it is necessary work. And it's going to set your family up for future generations. So, with that being said, I hope this was well for you guys. If you guys need anything, please message us or anything on our Instagram account.